This program is brought to you by Emory University.
We're going to go ahead and get started with the symposium today. Thank you all so much for being here. My name is Rich Kubiak, and I'm the editor-in-chief of Emory Law Journal. It is my pleasure to welcome you all to the 38th Annual Thrower Symposium. We're so excited to see so many students, professors, and practitioners here today to celebrate and honor the life and legacy of Mr. Thrower and to engage in a discussion that is sure to be engaging. This year's topic and symposium, Exploring Gun Violence in Modern America, law, policy, and social movements, is largely a response to the wave of mass shootings in the United States in the past 3 years. A church, a synagogue, a concert venue, high schools, and bars have all been the targets of shootings resulting in 10 or more deaths in the past 36 months alone. The problem with these mass shootings is not only pervasive in all aspects of our lives, from church to nightlife, but in all regions of our country, from Florida to Pennsylvania to Texas, Nevada, and California. But the problems with gun violence go beyond these mass shootings that only capture the public's attention for just a moment, unfortunately. Approximately 100 Americans die each day from gun violence, nearly 2/3 of which is from suicide rather than third-party crime, and another 250 are shot and survive. Today's symposium confronts these devastating realities, but also grapples with how we protect Second Amendment rights in this modern era. Throughout the day, you'll also hear about state and federal considerations for prosecuting gun-related crime, how mental health challenges contribute to gun-related violence, and the political pressures shaping gun policy. We hope that each one of you finds that today's symposium is thought-provoking, and we sincerely encourage you to engage with our speakers, as today is only the beginning of the conversation. The ideas and debates that we have here today will be taken forward and memorialized in an issue of Emory Law Journal next spring. That issue will benefit from your contributions during the Q&A session. So before we begin and before I introduce Associate Dean Seaman, I want to take a moment to thank all of the people who made today possible. First and foremost, thank you to the Thrower family. It is a testament to your support that today marks the 38th Annual Thrower Symposium. Today's event would not be possible without you. It's not only a marquee event for the law school, but it's a marquee event for the entire Emory community, and we thank you so much for your commitment to today's event. Additionally, I want to thank the Thrower Committee for your helpful guidance in shaping this year's symposium and also supporting Devin Sherrill, the Executive Symposium Editor, and the Journal throughout the planning process. In addition to the Thrower Committee, I would also like to thank the Emory Law faculty and staff. I specifically would like to thank Professor Pardo and Professor Smith, who are faculty advisors, and all the Emory Law faculty who are participating in today's symposium, including Professor Cloud, Professor Dietz, Professor Freer, Professor Shelf, as well as Professor Vandal. Thank you so much. And finally, I would like to recognize and thank members of the Emory Law Journal. Devin, the Executive Symposium Editor, has invested an incredible amount of time into planning today's event and worked very hard to ensure that today's event will be a success. And by his side, Lindsay Grubbs and Sarah Adams have also gone above and beyond to help in the planning process. In addition to Devin, Lindsay, and Sarah, the two L's who are sitting down here in the front are going to work hard today to ensure that every detail is executed perfectly. They are the next generation of the Emory Law Journal, and I'm confident that today's event and next year's volume will be a success because of their hard work and dedication. So, without further ado, I'd like to introduce the Associate Dean for Academic Affairs. Associate Dean Seaman teaches courses and seminars on evidence, constitutional law, and freedom of speech. She also focuses her legal discipline on interdisciplinary studies, considering the implications of brain science, social science, and cognitive psychology to various legal questions. and she is also a longtime board member and the most recent board chair of the Georgia Innocence Project, a nonprofit that works to free wrongfully convicted individuals using DNA evidence. Please join me in welcoming Dean Seaman.
Thank you, Rich, and good morning, everyone. If you're following good morning. If you're following along in your program, I am not Dean Hughes. As Rich said, I'm the Associate Dean for Academic Affairs. I'm delighted to welcome all of you to the annual Randolph W. Thrower Symposium. I offer greetings from Jim Hughes, who had to be out of town today. The Thrower Symposium stands as a highlight on the Emory Law calendar each year. The event brings together scholars, practitioners, judges, students, and other members of the community to explore a pressing legal issue from many angles. I'm particularly honored to have the opportunity to welcome you this morning because I have served on the Thrower Committee, the Thrower Selection Committee, a number of times. And just as the symposium is a standout event on the Emory Law calendar, service on the Thrower Selection Committee has been for me a highlight personally over these past several years. The Thrower Symposium is generously endowed by the family of Randolph Thrower. The Thrower family is represented here today by Patricia Barmeyer, Wilson Barmeyer, Randy Thrower, Laura Thrower-Harris, and David Bykoff. We are so grateful to you for your enthusiastic and unwavering support of this event. Randolph Thrower graduated from Emory Law School in 1936. Mr. Thrower embodied the values of intellectual curiosity, expertise, scholarly inquiry, and social justice that continue to inspire the symposium that bears his name. During his long and illustrious career, Mr. Thrower dedicated himself to service in both the public and private realms. He was a foremost expert on federal tax law, a lawyer for African-American death row inmates in Jim Crow, Georgia. He was appointed IRS commissioner by Richard Nixon. He was fired for resisting White House efforts to use the IRS to punish its political enemies through tax audits. Mr. Thrower passed away in 2014 at the age of 100. The Thrower Symposium is but one element of his wide-ranging legacy, and Emory Law is very proud to be its home and to be Randolph Thrower's alma mater. Before we begin, there are a number of people who deserve special recognition. Some of them have been recognized already, but they're going to get recognized again, so I appreciate your bearing with me. First, the members of this year's Symposium Planning Committee, Judge Frank Hall, Joseph Blanco, Professors Fred Smith and Raphael Pardo, Associate Dean Kay Levine, and Thrower family members Patricia Barmeyer and Wilson Barmeyer. Next, the members of the Emory Law Journal who worked so hard to make this event happen. In particular, Devin Sherrill, the Executive Symposium Editor, Rich Kubiak, the Editor-in-Chief of the Journal, Sarah Adams and Lindsay Grubbs, the Symposium Editors, and all of the 2L members of the Journal. There are also several Emory faculty members participating on today's panels: Morgan Cloud, Sarah Schalf, Rich Freer, Annie Dietz, and Frank Vandal. And finally, the Emory Law staff, without whom this day would not be possible, in particular, Rhonda Hermans, Amy Tozer, and Amy Marcellana. Please join me in an enthusiastic round of applause for this group of people who have contributed so much to make today possible. I thank all of you for being here, and I now invite Emory Law Journal Executive Symposium Editor Devin Sherrill to the podium to welcome you on behalf of the Emory Law Journal and to introduce our keynote speakers.
Good morning, everyone. Thank you for being here. Thank you, Rich. Thank you, Dean Seaman. Thank all of you for being here so early. I know it's pretty early for everyone. Trust me, as a third-year law student, this is the first time I've seen a sunrise in quite a while. So I understand how early it is, and I thank you all for being here. I promise it's going to be worth it. I'm going to try to be brief and not too repetitive, but I also have some folks that I would like to thank personally for making the symposium possible. First of all, I would like to thank all of our speakers and panelists that are here today. The attendance for this year's symposium, the registration, is the highest that it's ever been in the symposium's history, and that is a testament to the quality of speakers that we've brought here today. These are experts in gun violence, experts in mental health, social work, and I think they're going to provide a lot of insight and knowledge to you all today. I would also like to extend another thank you to the Thrower family for trusting us with this small piece of Randolph Thrower's legacy. It's a responsibility and an honor that we take very seriously each year, and we thank you for your trust in us at the Emory Law Journal. I would also like to thank the Thrower Committee. As Dean Seaman named each of you earlier, without your guidance and your help throughout this entire process, the symposium would not be a success. So thank you for your dedication each year, not only to the Atlanta legal community, but to Emory Law School and to the Emory Law Journal. I would also like to thank some folks behind the scenes that made this happen, put a roof over our heads and made sure that we had warm food. First of all, Rhonda Heermans, our managing editor, has made sure that since the beginning, the wheels stayed on the symposium, so I thank her very much for all of her help. I would like to thank Danae Duran, our marketing specialist, for the beautiful programs and posters and advertisements. Basically, if you saw anything that says exploring gun violence in modern America and it was aesthetically pleasing to you, that was Danae, I promise. I would also like to thank Amy Marcellana, our events manager. Amy has made sure that each and every detail is attended to and that we're all happy today, so thank you to Amy. I would like to thank the 2L volunteers that are here with the Emory Law Journal, also for being here very, very early this morning. Without you guys, the gears would not turn and this would not be a success, so thank you for positively representing Emory Law School and the Emory Law Journal. And last but not least, I would like to thank Emory Law Journal's 2 symposium editors, Sarah Adams and Lindsay Grubbs. They've been by my side this whole time, helping plan this. They've put countless time and effort into putting this together, and it would not have been possible without them, so thank you, Sarah and Lindsay. Now, with all that being said, I know that you all are on the edge of your seat, anxious to hear from these experts, so I'm not going to keep you from them any longer. I have the privilege this morning of introducing our 2 keynote speakers who will be having a conversation on the Second Amendment as it stands today in modern America. Our first keynote speaker is Professor Robert Cottrell. Professor Cottrell is the Harold Paul Green Research Professor of Law at the George Washington University School of Law. His writings on law and history have appeared in the Yale Law Journal, Georgetown Law Journal, American Journal of Legal History, Law and Society Review, Slavery and Abolition, a journal of slave and post-slave studies, and American Quarterly, among others. He is the author of The Afro-Yankees, Providence's Black Community in the Antebellum Era, and he's the editor of Gun Control and the Constitution, Sources and Explorations on the Second Amendment. He's currently doing research contrasting the role of law in the development of systems of slavery and racial hierarchy in the United States and Latin America. Our second keynote speaker is Professor Adam Winkler. Professor Winkler is a specialist in American constitutional law and the Supreme Court. He's the author of We the Corporations, How American Businesses Won Their Civil Rights, and Gunfight, The Battle Over the Right to Bear Arms in America. His scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments, and according to a 2016 study, he's one of the top 20 law professors for citations by the courts. His popular writing has appeared in the New York Times, New York Review of Books, Slate, SCOTUS Blog, and the Daily Beast. He's a frequent commentator about legal issues and has appeared on Face the Nation, CNN, NBC Nightly News, C-SPAN, NewsHour, ABC News, All Things Considered, Morning Edition, and Marketplace. He also served as co-editor of the Encyclopedia of the American Constitution. Please join me in giving a warm Emory Law and Atlanta welcome to our 2 keynote speakers, Professors Cottrell and Winkler.
Okay. Well, thank you very much. And I think both of us would like to thank the Emory Law Journal, the Thrower family, and particularly Devin Sherrill for his magnificent work in putting this together. having to wake up this early in the morning, I thought perhaps our discussion should be not about the Second Amendment, but perhaps the Eighth, given that at least for most legal academics, being up fairly early in the morning is cruel and unusual as such. But let's get started, if we might. Let me ask Adam, in your view, where are we with the Second Amendment in the courts today?
Oh, well, that's great. Thank you very much, Bob, and it's a pleasure and an honor to be here with you, and thanks, of course, to the Emory Law Journal, the Symposium editors, and all you for showing up. As so many of you know, in 2008, the Supreme Court, in the Heller decision, held for the first time, clearly and unambiguously, that the Second Amendment protects an individual right to bear arms. And the court struck down a law in Washington, D.C. that banned the possession of handguns in the home. This, of course, led to a wave of Second Amendment lawsuits. There's been over 1,000 lawsuits in federal court since the Heller decision challenging various aspects of American gun policy. Among all that litigation, one of perhaps the surprising things that's come out of it is how few laws have been struck down since the Heller case. There have been some, and there have been a few, to be sure. Handgun bans in Chicago were struck down soon after the Heller case in the McDonald case, where the Supreme Court held that the Second Amendment applied not only to the federal government, but also to state and local governments. But for the most part, what we've seen in the lower courts, especially at the circuit court level, is a real sort of consistency in the sense that the lower court judges, at the circuit court level at least, have really coalesced around an intermediate scrutiny standard for gun control measures. It's a little bit more complicated than the ordinary intermediate scrutiny, but it's basically a form of intermediate scrutiny. And applying this intermediate scrutiny, the courts have upheld the vast majority of gun control laws, including all of the major items that are on the top of the gun violence prevention movement's agenda, from restrictions on military-style assault weapons, restrictions on high-capacity magazines. Courts have not called into question background checks, and there's no reason to think universal background checks would run afoul of Second Amendment scrutiny. One of the big issues, may issue permitting for concealed carry, which most of the federal circuit courts have upheld, although there was a DC Circuit Court case just recently within the last year or so that held that DC's may issue discretionary permitting for concealed carry was unconstitutional, and said that DC was required to have shall issue permitting. That is some kind of objective standard that doesn't leave it to the discretion of law enforcement. And so we've developed, Heller has sort of encouraged a lot of lawsuits, but it hasn't resulted in a significant curtailment of American gun control policy. The question, I think, where we sit today is whether that's going to continue on in the future or whether that's going to change. The Supreme Court has recently decided to take a Second Amendment case, and that may change the future outlook of the Second Amendment and may lead lower courts, as we'll talk about later on, I'm sure, to apply a more vigorous scrutiny. So where we are is most laws have been upheld, and the courts, and there is some dissension. There are, Justice Alito said that the Second Amendment is being treated as a second-class right because not so many laws are being struck down. But I know you're not a big fan of some of the main proposals on the gun violence prevention movement's agenda, such as restrictions on assault weapons and assault military-style rifles. What's your view on that, and how should courts think about that issue?
Well, first of all, I tend to think that the assault weapons issue, the so-called assault weapons issue, has actually been a manufactured crisis in many ways. I've followed the history of the gun control movement for quite some time, and particularly since the late 60s when it became a national issue. One of the things that I think we frequently are treated to by the gun control movement is the notion that there's a particular bad gun. In the 1960s, we were told that the bad guns were World War II surplus bolt-action rifles using essentially 19th century technology. That was the type of rifle that Lee Harvey Oswald used to kill John F. Kennedy. And so we had kind of a panic over surplus bolt-action rifles and the idea that these must be curtailed, and the sale of them, particularly the Gun Control Act of 1968, was designed to curtail these. Then in the 70s and 80s, we were told that handguns were the bad gun, or perhaps only Saturday night specials were the bad gun. One of the things that happened is in the 1970s and 80s, the movement to ban handguns essentially failed. That is, it was rejected overwhelmingly by the American people, including in referenda in places like Massachusetts. You have a referendum in the 1970s in Massachusetts to ban handguns. In the most liberal state in the nation that had given its vote to George McGovern, the only state that did, this was rejected by an overwhelming margin. So by the 1980s, gun control activists were looking for something to revitalize the movement. And one activist, Joshua Sugarman of the Violence Policy Center, said, let's look at assault rifles or assault weapons as something that we could potentially ban. They look scary, and his words were, if it looks like a machine gun, people will think it's a machine gun. And the press would help that out, often help that process out by showing automatic weapons being fired when it was semi-automatic weapons that were under discussion. And one of the things, it seems to me that the assault weapons issue diverts us from first the fact that the real criminological problem in this country is misuse of handguns, not misuse of rifles. The number of homicides committed with rifles in this country is far fewer than the number of homicides committed with handguns. The assault weapons bans are frequently sold by the idea that, well, it has military features. So if you look, for example, at the gun ban that is put forward by President Clinton, rifles are banned if they have such features as bayonet lugs or pistol grips. Frankly, if I'm willing to let you have a rifle with which you can shoot somebody at 300 or 400 yards, the marginal damage that you can cause with a bayonet lug or a bayonet is somewhat minimal. That's not the thing that we should be afraid of. But also, let me say this. I think this continual shifting focus on this is the bad gun, that is the bad gun, the other thing is the bad gun, moves us away from what we really should be looking at, is not what type of gun should be generally available to the public, but who should be allowed to have guns. That the sensible or intelligent gun control should focus on who should be allowed to be a gun owner and not within very broad limits on what kind of gun an individual should be able to buy. But when we spend our time fighting over whether or not a bayonet lug should be allowed on your rifle, it diverts us from the how do we develop procedures to find which kind of people should or should not be allowed to own guns. And it's a question of evidence, which leads me to the question, what kind of evidence should be allowed in Second Amendment cases, do you think?
And this is this question of what kind of evidence should be allowed and what kind of evidence is sufficient to prove that a gun policy is likely to accomplish some positive public policy good is a big issue that's come up in the courts. The courts are applying this intermediate scrutiny, and for the law students and lawyers out there, intermediate scrutiny just requires that a law have a reasonable, sometimes a substantial fit to the underlying governmental objectives. And what we've seen is in the lower courts, the use of a variety of different kinds of evidence in weighing gun control policies, from the kinds of peer-reviewed studies that many of the people who are here participating in the conference do as part of their job, to expert testimony by law enforcement officers, police chiefs, and gun violence experts, to common sense logic about how the world operates. But in the lower court's use of evidence in these cases has been controversial, and many of the dissenting judges have said that the kinds of evidence that is being used is insufficient to prove the governmental goals are being accomplished. For instance, there was a case recently out of the Third Circuit, a case dealing with restrictions on high-capacity magazines that go into the firearm that can hold more than 10 rounds of ammunition. And the majority in that Third Circuit case upheld the ban on high-capacity magazines. And in dissent, Judge Bibas, a recent appointee of President Trump onto the Third Circuit, wrote a passionate dissent arguing that the court's use of evidence was insufficient. And he thought that we needed to show really strong evidence that this restriction on high-capacity magazine is going to do some real positive good. So much so that in the majority dropped a footnote saying that, that suggested that on their conversations that Judge Bibas really wanted to see empirical, peer-reviewed statistical studies that are very, very solid and sound to prove the effect of this gun policy. The majority's logic in the high-capacity magazine case was not based on these kinds of empirical evidence. What the court said in that case was there had been a bunch of testimony that supported these kinds of restrictions, that there is some empirical data showing that high-capacity magazines are often used in mass shootings. But moreover, the court said, we think that restrictions on high-capacity magazines can cause a shooter to have to reload. And in that moment of having to reload, that can stop a mass shooting, provide people the opportunity to intervene. For instance, the Jared Loughner shooting of Representative Gabrielle Giffords in Arizona, the large-capacity magazine that the shooter had jammed. He needed to try to change the magazine, and that's when someone jumped on him, and the shooting was stopped. The court in the Third Circuit case points out that if you watch the video of the Las Vegas shooting, where high-capacity magazines were used, along with the device that made it seem like a fire almost as quickly as a machine gun, and you watch the video, and there's all these bursts of activity, and then when there's a pause, that's when everyone gets up and tries to run away. And then the shots start again and they get down again. And the majority says, well, look, this is, by logic, there's a space here. And Judge Bibas said that's not sufficient. We want really much better, stronger evidence. Now, there's a certain irony in requiring empirical peer-reviewed study to prove the effectiveness of gun violence prevention laws, being that we have seen, as a result of NRA pressure, lawmakers make it very difficult to finance and shut off some of the main spigots of financing for these kinds of empirical studies. And also, we should note that the requirement of empirical studies, peer-reviewed studies, is not standard in constitutional law. It's true the courts will use them when they have them, and judges should always base their cases and base their analyses on the best available evidence, including the best available empirical studies that are out there. But in nowhere in constitutional law is it a requirement that you have these kinds of studies. The Second Amendment would be unique in that sense. And note, too, that one of the problems with requiring this very high level of evidence to prove these not only would make the Second Amendment unique in constitutional law, and not only suffers from the irony that so many of these studies have been stopped in their infancy or even before they were born because of the funding restrictions, but when judges use these studies, then they're criticized for using controversial studies. They're debatable, the results. Anyone who's worked in the social science area and the gun policy knows there's no study you can put out that's not going to be debated or controversial. And so the question of what evidence is required has been a really interesting controversy bubbling up on the lower courts. I wouldn't be surprised to see the Supreme Court try to clarify it in the near term, in this case that they've decided to hear soon. But Bob, I know your views are such that In addition to thinking about the costs and benefits, of gun policy and gun proposals, how should we think about opportunity cost? Is it just a question of sort of what we can accomplish with this law, or are there issues about what we're not doing because we're focusing on the wrong things?
Well, yes, I think that's a very important question. One of the things that sort of disturbs me in some of the argumentation that we get in the gun control area, and by the way, I would analogize it also to the capital punishment or death penalty area. I start off as a skeptic of both most gun control measures and of capital punishment. If you're not enraging both the right and the left, you're not doing your job. But one of the things that I've noticed in looking at the empirical studies in both areas, the death penalty and deterrence, we have a number of particularly economists who have argued that there is a deterrent effect with the death penalty. And we have a number of social scientists who have argued that particular gun control measures do some good in terms of reducing gun violence. And one of the things I've tended to find absent, and mind you, I'm not an empirical social scientist, so I'm kind of wondering what all these chi-squares and R-squares mean, and sort of, leafing through my SPSS book to sort of see what is it these people are talking about. But one of the things that I notice as sort of absent from this is the question of opportunity cost. To what extent, if we adopt a particular measure, are we drawing resources away from other measures? And one of the problems I have with many gun control measures is we will end up policing large numbers of essentially peaceable citizens and putting police and, in many cases, prosecutorial resources to bear that might be better spent going after violent criminals. This is anecdotal, but I recall a horrendous case that happened in New Jersey about 7 years ago. An individual was traveling from Utah to Maine. He was traveling by plane, and somehow the plane was diverted to Newark. And the airline gave the man his guns, which he lawfully owned in Utah and could legally use in Maine. I believe he was on a hunting trip or some such. In any event, he ran afoul of the New Jersey gun control laws. He was arrested, put in jail, awaiting trial. Ultimately, he was released, but it occurs to me, what can be going on in the minds of the police officers and prosecutors who are going forward with this case? Are the streets of Newark and Trenton and Camden so safe that that the New Jersey authorities can devote quality time to travelers from Utah who happen to be mislaid or stranded in Newark? And one of the things I think we have to ask with gun control policy is, how is it that law enforcement bureaucracies and prosecutors' offices actually work? And to the extent that we criminalize peaceable citizens who simply run afoul of gun control statutes, are we not only doing injustice to these citizens, but in fact diverting resources that really should be spent on the problem of criminal violence as such. Let me ask you this about the new Second Amendment case that you mentioned, the New York State Rifle and Pistol Association versus New York City. What is it, and what do you see happening with that case?
Well, this is the big Second Amendment case. They just last week or a week before just decided to hear another Second Amendment case. They won't hear it until the fall in the next term. But as you said, the New York State Rifle and Pistol Association versus New York has the potential to be a very major Second Amendment case, one that really reshapes American gun policy. At the same time, it has the potential to be a very minor case that does absolutely nothing and no one will pay attention to. Which way they go, I can't really tell you. The reason why I say it could be a case that goes nowhere is that the law at issue is a unique law that the court could strike down without really impacting gun control policies anywhere else in America. The law at issue there is New York City requires, if you want to have a firearm in your home, that you get a permit, what's called a premises permit. It does not, that permit allows you to keep the gun in your home, a particular gun in a particular home, and allows you to take that gun out of your home only for certain specified reasons and to specific specified places under the statute, such as a gun range, certain gun ranges within New York City. But you can't, for instance, take your gun to a gun range outside of New York City. You can't, as one of the plaintiffs in the case has a second home in upstate New York, he can't take his gun from one home to the other home. This kind of transportation restriction is a very unusual kind of provision. Not very many places even require you to have a permit to have a gun in your home. So the court could say, look, this is a unique law, we're gonna strike it down and not have any big impact on gun policy. I think that's highly unlikely that the court will do that. I think the reason why the court has taken this case now is because the court is ready to make some pronouncements about the Second Amendment. For those of you who have been following, since 2010, the court has pretty much stayed away from the Second Amendment. There was one decision on a Massachusetts stun gun issue where the court weighed in briefly with a short per curiam opinion, but not a huge landmark case. And indeed, the Supreme Court has avoided taking a Second Amendment case over and over and over again. The lawyers behind the Heller case have been back to the Supreme Court several times with petitions for cases challenging things like discretionary permitting, things like restrictions on military-style assault rifles, and a whole bunch of other sorts of restrictions on guns and gun purchasing. And the court has just consistently in the years stayed away, said we're just not going to take that case. And we don't really know why. The court doesn't offer any reasons why it doesn't take cases, but we know this much. It only takes 4 justices to take a case. So if the reason why the court wasn't taking the cases was at least tied to the fact that you couldn't get 4 justices to take the case. Why couldn't you get 4 justices? Well, that was kind of surprising. You had a 5-4 majority in the Heller case. You'd think there would be 5 justices who are ready to expand Second Amendment rights, or at least to clarify their scope. Most sort of Supreme Court watchers have speculated that Justice Kennedy was an uncertain or hesitant sort of Second Amendment warrior, that he was with the majority in the Heller case, but that no one was really sure, even among the justices, which way he'd go on some of these other cutting-edge Second Amendment issues, such as May issue permitting and restrictions on military-style rifles. And indeed, we know that many of the justices, such as Justice Alito, Justice Thomas, Justice Scalia, and then his replacement by Justice Gorsuch, all filed dissents from these denials of certs, saying they want the court to take these cases, which suggests, again, that they weren't able to get the votes of Justice Kennedy and Chief Justice John Roberts. Well, Kennedy's now been replaced. Right, Kennedy's been replaced by Judge Kavanaugh. Judge Kavanaugh, when he was a lower court judge on the D.C. Circuit, wrote an opinion, a dissenting opinion in a case called Heller 2, where he articulated very forceful and strong views of the Second Amendment and called for a more expansive protection of Second Amendment rights. And disagreed with the intermediate scrutiny that was being applied by the lower courts. And so the Supreme Court has taken this case and taken it now. I think what explains it is Kavanaugh joined the court, and within 6 months, the court takes a major Second Amendment case. I don't think that's an accident, and I think there are now the votes clearly to take a case. And it really comes down to, as so many things will come down to over the next few years, what will John Roberts do? And that we just don't really know for sure, honestly. One of the things that one of the reasons why we know that several of the justices are so eager to take on another Second Amendment case, Bob, is that some of the justices, including Justice Alito, have said that the Second Amendment is being treated like a second-class right. And the argument being that too many laws are being upheld, the courts are not skeptically reviewing these gun measures. What is your thought on whether it's really a second-class right? Are the courts doing an insufficient job in protecting this right? Something that, in truth, the Supreme Court, we all love the Supreme Court, but it's done a pretty bad job of protecting a lot of rights.
Oh, yeah.
So this would not be unique.
Yes. Well, I've always made the parallel between what the court has done in modern times with the Second Amendment and what the court did with the 14th and 15th Amendments at the beginning of the 20th century. The 15th Amendment, the right to vote not being abridged by reason of race or color, was essentially a dead letter in large parts of the country, particularly in the southern states. And also 14th Amendment equal protection, at least with respect to race, was very much a dead letter. The Supreme Court took heroic efforts to avoid actually applying those particular provisions. And I think that's what we've had with the Second Amendment. Quite frankly, I think since the case of United States versus Miller, the 1939 case that has been claimed by both sides of the individual right versus collective rights debate. But if we even look post-Heller, I don't think the court, some of the courts have been applying what I think might be a genuine intermediate scrutiny. But certainly if we look at the Second Circuit with respect to the current case, New York State Rifle and Pistol Association, I don't see how we could really claim that it's intermediate scrutiny that an individual who has a permit to have a pistol in his home, and even that I think might be constitutionally problematic, but the New York City procedure normally takes 6 months for an ordinary citizen to get a permit to have a pistol in his home. The person has been investigated 7 ways from sundown before getting this permit. To say that that individual is untrustworthy to carry in a locked box the firearm to a range in New Jersey or Connecticut or upstate New York or to a second home in one of those places, to sustain that and say that you're applying intermediate scrutiny, I don't think that's intermediate scrutiny, at least not the way I learned it. So I think that there is a judicial hostility, a lingering remnant, if you will, of the hostility that existed pre-Heller to even recognizing the Second Amendment as a right of an individual. And it still continues, I think, with many of the courts, many of the circuits, who I think have upheld many gun control measures on relatively flimsy evidence, more evidence than I'd like to see if we were genuinely applying intermediate scrutiny. But let me ask, how do you think the Supreme Court might rule in this case and in future cases with respect to the Second Amendment?
Well, I think it's it's a real open question. As I sort of referred, it could be a whimper, it could be a nothing burger case, or it could be a huge case that sets some really important precedents. Why I already said why I thought it might be a whimper, right? It's an unusual law, it could be struck down without major implications elsewhere. I think it's more likely to be a bang case than a whimper case, because I think the reason why the justices took the case is because they want to clarify the scope of the Second Amendment. They want to start answering some of the questions that the lower courts have had for years that the Heller and McDonald case left open. Among those two things in particular, this is the first Supreme Court case to raise the question about what is your Second Amendment right outside of the home. The Supreme Court in the Heller and the McDonald case, both those cases were talking about handguns in the home. And although some of the language of the Heller case talks about firearms outside of the home, that is arguably dicta, and the lower courts have said that Heller is limited in some ways to the right to have a handgun in the home. Most lower courts have said nonetheless that the right does extend outside of the home, but have upheld most laws that restrict guns outside the home. Most gun control advocates have thought that and many gun rights advocates have thought that the big Second Amendment case that they would take on guns outside the home would be dealing with may issue permitting for concealed carry. That's a much bigger issue than New York's transportation restrictions for premise permit holders. But that hasn't been what the court has taken. The court's taken this case, but I think, and while this case will not decide the concealed carry issue, I think the court is very likely to articulate principles for how to understand the Second Amendment outside the home that will have a big impact on how courts going forward think about concealed carry and may issue permitting. So I think the court's going to articulate broad principles that could reverberate through the concealed carry debate and ultimately lead to overturning of may issue permitting in cities like Los Angeles, San Francisco, New York, Boston. To put that in some perspective in terms of numbers would mean a lot. In Los Angeles today, there's less than 500 people who have concealed carry licenses who are ordinary civilians, not retired police officers. Based just on demographic estimates from what we see in other states, including Georgia, that we should expect to have several 100,000 people carrying guns with concealed carry permits if we allow concealed carry in Los Angeles. So it might make a big difference in gun policy in places like Los Angeles. I think the other thing is, over and apart from questions of guns outside the home, I think the court wants to step in and clarify the standard of review. Either say that the lower courts are right about the standard of review, more likely say the lower courts are onto something with the standard of review, but we want to see more evidence or we want to see a stronger version of intermediate scrutiny, or possibly even raising a choice of a different standard, something like a strict scrutiny standard. And the standard of review question is so important because it'll apply to gun control issues, gun violence prevention policies across the board. Right, not just outside the home, but inside the home, and any kind of gun policy would be subjected to that higher standard of review. So that's going to be obviously a pretty huge issue. One of the things I say to look for is it could very well be that we'll have a divided Supreme Court, even among the majority on the standard to apply. Judge Kavanaugh's rejected the two-part test, the intermediate scrutiny test, and said we have to do this on the basis of history and tradition. I think that's unlikely to be an approach that gets 5 votes, but you never know exactly what's going to happen there. When the Supreme Court thinks about these issues, though, Bob, I mean, should it be thinking about over-criminalization? Is that an issue that the court should be concerned with? You've mentioned that we should be concerned about in some ways.
I think the court should be concerned with it. It's hard, I think, for the court to look at it because how do you constitutionalize the issue of overcriminalization? But as a policy matter, it's something that I think we need to be very concerned with. We're concerned with the question, we need to be concerned with the question, are we overusing the criminal justice system? Are we criminalizing activities and people at very real costs who are not in fact criminals? And this relates again to the opportunity cost issue, to the extent to which you are using criminal justice resources to arrest, to prosecute, and to imprison people who basically are not engaging in violent crime, but who are simply running afoul of laws, of particular laws. One of the things I'm always concerned with is how do we try and strip our criminal justice system, or our criminal justice laws or statutes back to the malum in se core to the extent that we can, to the extent that we are going after individuals who are not engaged in the business of violent crime, who are not in fact predators. One, we are punishing people who in fact do not deserve, by any reasonable standard, criminal justice punishment, and we are taking resources away from dealing with violent individuals who in fact are predators. And to the extent that we build more gun control laws that are going to go after essentially peaceable citizens who simply have guns that we have decided for whatever reason that we think should be banned or that we don't like, we're taking away resources away from from the business of going after violent predators. One of the things that bothers me, about, for example, our focus on mass shootings are horrifying. They draw our attention, but they also draw our attention away from what is the real gun violence problem in this country. And the real gun violence problem, unfortunately, is the day-to-day carnage that occurs in many inner-city communities by people by what I call a microculture of hyperviolence that exists in some communities. And we're not addressing that problem, and we're focusing on events which in many cases are freakish, almost impossible to predict, and which are going to elude solution from almost any of the control measures that we put forward. I'm afraid that we're diverting our attention from what is the real gun violence problem in contemporary America.
If I could add to one thing to that, and just some things of overcriminalization, sometimes the problem isn't just going after the wrong people. Sometimes you're going after people who are actually committing a crime and doing something wrong, but the result is one that might not be, that might come in conflict with criminal justice reformers and whatnot. So I think one of the unfortunate facts about a lot of gun policies is the disproportionate impact on racial minorities and on the poor. In the sense that, so for instance, California recently banned high-capacity magazines. I don't think banning high-capacity magazines in an ideal world is necessarily a bad idea. If we could get rid of them all, that might be a great thing. The problem is you can't really get rid of them all, right? You can pass a law banning them. And so what happens in California? Well, no one's turned them in. No one's gotten rid of them. No one who owns them is not going to own them anymore, or very few people are going to throw them away. So what happens? Well, the police don't enforce the law in the sense they're not going out and searching people's homes to take away their high-capacity magazines. So are there any arrests for it? Well, sure, people get arrested if they're stopped for other reasons or arrested for a crime and they have a high-capacity magazine. Well, now they'll be charged with the additional penalty of having a high-capacity magazine. And that's going to be, we know, disproportionately, that's going to be, criminal enforcement is going to be against racial minorities disproportionately and against socioeconomically disadvantaged people disproportionately. Meanwhile, the wealthy people or the middle-class people who have the high-capacity magazines are still going to the gun range and using them. And they're not getting arrested, and no one's enforcing the law against them, because they're not running into police officers who are searching them and finding the high-capacity magazine. And so what you'll have in California in a few years, we'll find that 70% of prosecutions for high-capacity magazines are against racial minorities and the poor. Now, this is not necessarily a reason to avoid passing a gun policy, but we should be very cognizant of the effect of this kind of criminalization that it has on racial minorities and the poor too, and we shouldn't ignore that issue. And it's part of the reason why gun advocacy reform groups have come in conflict with criminal justice reform groups that often are on the same sort of side of the ideological spectrum, but there is that conflict.
Well, in fact, to add to what you're saying, this is the high-capacity magazine law. By the way, I would say in an ideal world, I would be against it, take a different view, but it's a law that cries out for selective enforcement, or is inevitably going to create a problem of selective enforcement. And indeed, I'll go even one further. The police officers who are more likely to arrest minority residents who have high-capacity magazines will go to the shooting range and be right next to their buddies who will have high-capacity magazines who will shoot at the shooting range. So you're going to get a tremendous problem of selective enforcement in this area. Let me ask you this: you mentioned the criminal justice reform movement and the gun control movement. How do you see social movements as impacting the future of the Second Amendment?
Well, it's great, and it's important as part of this conference to be thinking about social movements and how social movements change the law, because that's what we've seen in the Second Amendment. The Second Amendment, the Supreme Court's enforcement of Second Amendment rights is the result of a social movement to protect gun rights in America that's been very powerful and very forceful and not illegitimate, right? This is how constitutional law is often done, by the pressure of social movements, from the civil rights movement to the women's rights movement, and the gun rights movement is part of that too. You might not say those movements are equivalent, and they're not, but they are both similarly shaping constitutional law by creating of political pressures, by elections that lead to justices, right? There's going to be a big difference in the outcome of this Second Amendment case because of the election of 2016. Right? Because conservatives, Republicans won that election and won majorities in both houses, more importantly in the Senate and the White House. They got justices appointed to the Supreme Court who have broader views of the Second Amendment than would have been appointed by a President Clinton, to be sure. And so when we see the Supreme Court taking a case, it's a result of a social movement being successful and winning. What's interesting is that we are seeing the rise of a much more forceful gun violence prevention advocacy movement than we've had in a long time in America. Just people say that ever since Newtown, you often hear people say, oh, nothing's changed since Newtown. First of all, the laws in about half the states have changed, and so most people are living under laws that are different today than they were under before Newtown. But even over and above the law on the books, there's been a real vibrant growth of a gun violence prevention movement with money, with organizations, with more researchers getting involved here. And we saw after Parkland, the students have brought a lot of political activism to the mobilization. And that gun violence prevention, which 10 years ago was at the bottom of the Democratic Party's political agenda, an issue they liked to avoid talking about because it was going to hurt them on Election Day, to now it's an issue at the very top of the Democratic Party agenda, thought to be in some circles a litmus test in the Democratic Party these days. That's the result of a real fundamental shift that's happening in America with the rise of this gun violence prevention movement. And it'll be interesting to see how those pressures will also work to influence the court. We're going to open it up to questions in a minute, Bob. I wanted to ask you just one more question. I think for some people in the room, there's going to be a divide. Some people think that, that the real problem here is the Second Amendment, that we need to get rid of the Second Amendment. Justice Stevens has called for overturning, repealing the Second Amendment to the Constitution. Should we think of the Second Amendment as a problem in America, or in your view, is it more a solution?
In my view, I think it's more of a solution, and I would say in two ways. One way is if you're really interested in gun control, as opposed to gun prohibition, and I think there's a distinction between the two, the gun control movement, I think in many ways shot itself in the foot by essentially saying the Second Amendment does not exist. It has no constitutional weight. We can essentially prohibit all firearms ownership. It's simply a matter of legislative discretion with no constitutional limitations. That created a mass movement, and make no mistake, the NRA is a mass movement, opposing any measures or virtually any measures at control. If your interest is control, how do we develop screening measures to determine who should be eligible to have a firearm, and how do we determine who should be eligible and the purchase of firearms? You're not going to be able to do that without massive opposition unless you in fact recognize there are constitutional limitations. The fact that the gun control movement said the Constitution has nothing to say to gun control created a mass reaction against any kind of gun control movements. But I think also the Second Amendment might be part of the solution in terms of its original purpose. The original purpose was to have the population armed with an ability to play a role in the protection of their own communities. That's the notion of the well-regulated militia. And I think we ought to look at that concept and see how it might work in its modern form. And its modern form is not to have a flintlock musket and stand in the town square waiting for the British invasion, as it were. The modern way of doing it is how do we get citizen participation in the defense of the community? One way, for example, that we're discussing right now and that we ought to look at is arming school teachers in terms of as a hedge against the possibility of school shootings, and other ways of trying to engage citizens in the physical defense of their communities. And by the way, that requires a mindset which is in many ways very different from the mindset that we've developed in modern times. We've tended to develop the idea that the average citizen is helpless, is feckless, cannot play a role in her own defense, that we need individuals who are professional arms bearers, who somehow have a wisdom and a skill that we as ordinary people don't have. Now, the police, it's true, do have a training and presumably a screening that the ordinary citizen doesn't have. Though when I hear cases of St. Louis police officers shooting their colleagues in games of Russian roulette, I kind of wonder about that at times. But yes, police do have special training, but we have all sorts of other people who don't have significant amounts of training who nonetheless provide armed securities. Most private security guards, for example, have something on the order of 2 weeks of training. Are we saying that teachers cannot approximate that level of skill? Or one thing that I found very remarkable is several years ago, we were debating whether or not we could trust airline pilots with guns to prevent hijackings. And we were saying, all sorts of people saying, well, they can't do that. You know, we don't know about the mental health of these pilots. If we're unsure of the mental health of the pilot, don't get on the plane. Or, well, the pilot can't master the skill of handling a handgun. You can fly a 747 and not master a 38. I tend to wonder about that. So the idea behind the Second Amendment is that the citizenry is capable of playing a role in the defense of the community, and I think that's an idea that should be revived and modernized.
We have some time for questions, I believe. There's some microphones, two microphones set up. So if you have your questions, please come to the microphone.
Good morning. Thank you for such an engaging discussion. I wanted to go to something that you mentioned earlier in the discussion when you talked about shifting the focus from banning certain types of guns to really focusing on who would own those guns. And I think that with the Las Vegas shooting, they have not been able to determine a motive and really haven't found anything in the shooter's background to indicate he was capable of such a heinous act. So how would you go about looking for characteristics, features in a person to determine whether or not they have that ability?
Well, okay, let's first of all be honest and engage some bad news. We're not going to find every case where a person should have been prohibited from having a gun. That having been said, we actually need a dialogue about what kinds of individuals should be banned from owning guns. Now, the 1968 Gun Control Act prohibited felons, for example, from having guns. I have a question as to whether that should be a lifelong prohibition for somebody who had a felony in their way remote, distant past. On the other hand, you know, one of the things we should ask is, well, look, if a person has a history of violent misdemeanors, might we at some point say that individual should be prohibited? And that should be part of the national dialogue as to, okay, you know, what sort of conditions should, in fact, cause you to lose the right to keep and bear arms. We need, in my sense, more of an examination of our mental health system and who, under what circumstances or what conditions a person should be prohibited. The difficulty is, I don't see that we can get the kind of national dialogue that can ask these kinds of questions and have both sides agree that, under these circumstances, a person should be prohibited and others should not. We can't have that kind of dialogue as long as what we're really talking about, or the elephant in the room, is prohibition, which unfortunately it often is.
Thank you.
I think that this, by the way, this is, one thing you have to remember, when you have 400 million, that's when we start out with 400 million guns in America approximately. Mm-hmm. So you start off with that number. Every policy choice has to be made in light of that fact, right? And part of the reason why I think you need to focus on things like the identity of the person, trying to keep those, because you can ban a particular weapon, but if the person can get their hands on another weapon, they're going to do a lot of damage.
Right.
And we're seeing, we often hear that there's nothing happening in the gun control movement, as I said earlier, or nothing's happening in gun control. But there has been a real move at the state level focusing on making it harder for people who are domestic violence abusers, domestic abusers in the domestic violence case, to get their hands on guns. There's been a wave of laws, even passed in red states, making it harder for domestic abusers to get their hands on guns. We've seen the rise of these red flag laws, these gun violence prevention orders that are really kind of taking off, being adopted by a number of states in just a few short years. And they are focusing on this question of trying to identify especially dangerous people and keeping guns out of their hands.
Let me also say something about the type of gun. If we think of the Las Vegas shooting, the tactical position that shooter was in, reminds me somewhat of Charles Whitman in the Texas Tower. That is, you're in a spot that's hard to get at, you've got the high ground. Charles Whitman, killed 11 people with a bolt-action rifle, basically. The idea that one gun is somehow safe and other kinds of guns are somehow not safe, I think ignores what could actually be done if you place yourself in the right kind of tactical position.
Yes, I'm curious to know whether each of you thinks that the Heller decision was correctly decided.
Excuse me?
Was the Heller decision correctly decided?
I think so, yeah.
I think so. Mm-hmm. Part of the reason, by the way, you can have people who have very different views about gun policy, as Bob and I do. Maybe they haven't all come out in this debate, but in this discussion, but we have very different views on gun policy. Heller allows that, right? Heller says there is a right to bear arms. My positions, again, I start with the 400, right? Once you got the 400 out there, you could say there's no right to bear arms. There's 400 million guns out there. There's a right to bear arms, whether it's a de jure right or a de facto right. On the ground, there's going to be, people are going to have access to guns. And Heller makes very clear that there's broad space for lawmakers to regulate guns in the interest of public safety.
Yes, the 400 million, I think, is a very important fact that we need to deal with. I was once discussing gun policy and gun control in the United States with a European who was very much a gun control advocate. And when I gave him that figure, he said, well, forget about it. You don't have to argue about what the Second Amendment means. If you've got 400 million people with guns, or 400 million guns, sorry, in private hands, the right of the people to keep and bear arms cannot be infringed. But, yeah.
Like it or not, right?
Yeah.
I would just like to try to speak for the students at Marjorie Stoneman Douglas and ask you, Bob, if you have anything more to say to those wonderful surviving students other than what occurred was freakish and there's nothing we can do about it. That is, the same thing could happen this afternoon, tomorrow, 5 years from now.
Well, let me ask you, what do you think could be done about it, and what do you think might make a difference?
Sure, great question. First of all dangerous vehicles are registered, so that's a starting point. We need gun registration so we can find the bad guys. The second thing is insurance. Women who are in a home where there is gun are 500 times more likely to be shot. So I would say registration and insurance, just like we do for cars and airplanes and other dangerous vehicles. The third thing would be storage, that there should be meaningful storage of guns both in the home and outside the home.
Okay, an individual decides he's going to go to a school to murder teachers and students. How is the fact that his gun is registered or stored or insured going to stop that?
We can start counting the number of guns that an individual has, particularly serious weapons, such as in the Las Vegas shooting. That person had a small armory. So that is one criteria that we can use to start to pinpoint explosive individuals. The crime rate in Boston was dramatically reduced because the police would go to people with bad records and say, there was a murder today, maybe you might be involved. And they did this on a very aggressive basis. And pretty soon the bad guy said, maybe I might not engage in that. So the same thing would happen to shooters that like to shoot. When people buy guns, they like to shoot. There are several articles on this.
Well, I'm not at all concerned with people who like to shoot at paper targets. My concern is people who like to shoot people. And if I've decided to go into a school and murder teachers and students, I've already decided that my life is going to be over anyhow. So the fact that my gun is registered or insured is not going to stop me.
Yes, but we've given
Professor
you...
Vandal, we do thank you for the thoughtful discussion and raising the question and stirring such interesting debate on this topic. But we're going to actually close off the questions now and take a short break for about 5 minutes, and we're going to reconvene for our next panel around 9:30. Thank you.